Hello friends, good afternoon to all of you. I am J.S. Saroha. I have been continuously in touch with you with regard to the industrial relations and labor law matters. I will be taking up Industrial Relations Code, which consists of Industrial Disputes Act 1947, Trade Union Act 26, Industrial Employment Standing Orders Act 1946. Actually, Government of India has been preaching for quite some time that they will be bringing out revolutionary labor reforms which will boost the industry and will be very beneficial to the employees. That is besides the question. In any case, there has been simplification and codification of all old 29 acts into 4 codes. So old laws have been repealed and now entire industrial law is in 4 codes. The code on industrial relations is very important from industrial peace point of view. Industrial relations can be maintained well if these acts are well complied with. Now, I will take up Industrial Relations Code, preliminary Chapter 1. Appropriate government. Central government is appropriate government. For Government of India, PSUs, it has to have 50% plus holding, but even if the holding is reduced to less than 50%, appropriate government will still remain the central government. Railways, metro railways, telecommunications, banking also have been added in this. Appropriate government for state public undertakings. State undertakings are to be guided by the state government. Therefore, their management and the appropriate government in their case is state government. Appropriate government for certain specified industries, certain controlled industries which are governed by Government of India. So appropriate government in the controlled industries is this central government. Employee. Definition of employee has been very exhaustive. It takes into consideration workmen from unskilled up to managerial level, except apprentices under Apprentices Act. Employer. Definition of employer has been completely modified, and it means head of the department of the central or state government, occupier of the factory, manager of the factory under clause F of section 1 of 7 of Factories Act 1948, the person who has authority or has ultimate control over the affairs of the establishment, then contractor and legal representative of the deceased employer. Here, I would say that for Factories Act being occupier, director has to be one of the occupiers. Fixed term employment. The fixed term employment existed in Industrial Employment Standing Orders Act and was incorporated 2 years back, but with a very small notion. In the code, fixed term employment has been elaborated, well defined. It means that all the benefits available to permanent worker will be payable to the fixed term employee. Besides, fixed term employee will be getting gratuity only on completion of 1 year service. Industry means any systematic activity with the cooperation of employer and workmen to satisfy the human needs. In the definition, substantially engaged in charitable, social, philanthropic services and certain functions have been excluded. Industrial establishment or undertaking any unit or such establishment which part of the same venture can be severable, and that part which we want to say severable from the main plant means by the closure of that plant, there is no effect on the activities or production of the main plant. Recently, we had obtained permission for closure of a department of factories like Rico Auto Industries. There, some parts were severable, and therefore they have been treated as separate unit. Strike, it includes if concertedly 50% of the workmen resort to casual leave. Lockout means the temporary closing of place of business or suspension of work of operations. Strike is weapon in the hands of workers. Lockout is weapon in the hands of employers. Lockout consequent upon illegal strike is justified and legal. But lockout is a situation which is created to be attributable to the conduct of the workers. Such situations like strike, gherav, sit-in strike, obstruction in working, etc. Trade union dispute has been added in these disputes. Trade unions arising to unions or between work members of the trade union. Wages means all remuneration, whether by way of salary or allowances, expressed in terms of money, which include basic wage, BNS allowance, and retaining allowance. Then in the section from A to I, subsection A to I, are the components which, if put together, amount to more than 50%, then that amount will be treated as wages. But worker now includes supervisory capacity earning wages up to 18,000 rupees. But workers' definition has been in dispute because worker is a very wide subject, wide term so far as the industrial law is concerned. Managements have been calling some of the staff members as worker, whereas where there is an element of supervision, primary element of supervisor is out of the purview of workman, otherwise he will remain as a workman. Don't include managerial, administrative, apprentices, etc. Employee includes increased worker. Employee includes working journalists, sales, promotion, newspaper employees as defined. Code defines discharge, dismissal, retrenchment, or otherwise termination of service of a workman. And then individual workman can file a case for reinstatement for resolving his dispute. If demand notice is filed and within 45 days there is no settlement, then the workman can approach the industrial tribunal directly and the dispute will be taken as a reference and tried as a reference by the tribunal. Grievance Redressal Committee members have been increased from 6 to 10. Establishment employing 20 or more persons, workers, it will be applicable. Redressal committee will consist workers as well as employer, equal number. Women representation has to be proportionate. There will be chairman of the committee, which will be rotational. Once it will be for the management side, next time it will be by the workman side. Sole negotiating union, where the union having 51% of the workers, it will be sole negotiating union. When there is no union which comprises of 51% of the workmen, there will be negotiating council. Where there is a multiplicity of unions, then the 20% of the workers number will be one representative for each 20%. Recognition of union is by 3 to 5 years. If there is a settlement between negotiating or council, then it will amount to a settlement under the Act. Facilities have to be provided, negotiating union, which will be decided and prescribed by state government. Registration of union will not be registered, union will not be registered if 10% or 100 number of workers are not there. That is the limit for registration. Appeal against registration cancellation will lie before industrial tribunal. Office bearers of unorganized sector, where there is unregistered, registered union and unorganized sector, 50% of the office bearers will be workers really engaged or employed in that industry, and workers who have been retired or who have been retrenched will not be counted as outsiders. Standing orders. The threshold limit has been raised to 300 plus more. It can be reduced or increased by the appropriate government. In the state of Haryana, previously this threshold limit for standing orders were 100, but in Haryana it was 50. Employers required to prepare draft standing orders within 6 months of the commencement of the Act code. For consultation is required even when the draft to be finalized. Consultation with union or negotiating agent for making draft of standing orders. Previously, it was the employer responsibility to draft standing orders and submit them for certification. Employer can adopt model standing orders and they will be deemed as certified. Certified standing orders, employer files this draft, the certifying officer sends a copy of the draft to the negotiating union or council or the workmen representatives to be chosen for standing orders to be certified. The election of such representatives is held by an officer of the Labor Department to choose 3 or 5 representatives amongst the workers. Standing orders which are already there, they will continue to be certified standing orders. Appropriate government may, by notification or direct provisions of the said section of notice of change, subject to the conditions as may be specified. Industrial dispute can be voluntarily referred to arbitration by employer as well as workers. Again, workers to be represented by negotiating union or council, and where there is more than two arbitrators, one arbitrator will be appointed as umpire, and his decision in case of dispute will be final. Conciliation officer shall hold proceedings relating to industrial dispute not after 2 years. So demand notice and the dispute have to be within 2 years. Voluntary referred to the arbitration by employer as well as workman by written agreement. Conciliation proceedings shall be deemed to have been commenced on the first date of meeting of the conciliation, and it will be deemed to have been concluded on settlement being signed by the parties. 2. When the conciliation officer records his finding that no settlement is possible and he closes the proceedings. Within 90 days, the concerned party can approach the tribunal. Notice of termination of settlement. The parties can give 60 days notice for termination of the settlement on the expiry of the settlement. No civil court other than the tribunal shall have power to entertain any suit, other proceedings in relation to disputes referred to in subsection adjudication of tribunals. Limitation of recovery of money due from employer. If the money or the claim is under settlement or award or amount payable under chapter 9 and 10, this section will be 59(1). Whereas there are other amounts payable to the workmen from the employer, that section will be 59(2). These sections are from the old act, duplicates of the same old 33(1), 32. 33(2) means 59 within bracket 2 section means that no new rights can be created under this recovery proceeding. Rights already adjudicated upon and the amount to be recovered from the employer can be put under this section. Publication of awards of industrial tribunal as outcome of dispute. Now, previously, the awards were sent for publication to the government, and it used to take months together for publication, and sometimes to delay the proceedings, employer would not allow the publication to happen for months together. This, to overcome this problem, this code says that award is executable within 30 days as if it is decree of land area. It's code of civil court. Interim relief, tribunal can of course grant interim relief to the workers in termination of services. Interim relief is made when prima facie it looks that the workman was not given an opportunity of being heard. So, right at the beginning itself, an application comes from the worker when he has been illegally terminated that he should be compensated by way of interim relief. Legal position in this subject is interim relief can be awarded, of course, by the tribunal, but where domestic inquiry has been conducted, the fairness of domestic inquiry is a preliminary issue, that whether the inquiry is fair and proper, and then termination of the employee. Where inquiry has been conducted by the employer, the issue of inquiry will be decided first, then only question of interim relief will come. That's why Many a times employers say to us that this man has conducted himself in such a nefarious manner and his services should be terminated forthwith. Then legal reply to that question is that if domestic inquiry is held, court will see prima facie there is a case against the workman and in favor of the employer, and interim relief application will not lie. But if direct termination is there without giving opportunity of being heard to any workman, then court can start giving interim relief, and that relief will continue irrespective of the years court takes. So far, industrial tribunal has been headed by one presiding officer, but as a result of this code, now there will be two members, one from judicial side, other from administrative side. Next. Prohibition of strikes and lockouts. All establishment without giving notice. Then strike and lockout will also be illegal when conciliation proceedings are going on, when there is a reference of a dispute before tribunal, it is going on, and where there is an award against any party, or there is a settlement in operation. During that period, strikes and lockouts will be illegal. Next. Prior permission of the government for closure, layoff, and retrenchment. Now, this limit has been 300. Previously, it has been ranging from 500, 100, between this. Now, if a establishment wants to close or lay off or retrenchment, then permission of the appropriate government will be required. For that, an elaborative detailed document is to be submitted by the employer giving reasons of layoff, closure, or retrenchment, and justifying what actions management has taken to avoid closure, layoff, or retrenchment. The parties will be called by the appropriate government labor commissioner state in Haryana, who will reply the questions raised by the management in the closure, layoff, and retrenchment applications. If there is a recruitment of employees, workmen within 1 year of retrenchment, he shall be given priority to the retrenched workmen. A new fund has been created under Section 83 of the Code. Employers shall contribute amount equal to 15 days' wages last drawn for every retrenched worker in the fund, which shall be credited to the retrenched worker. Actually, the fund will be maintained by the government, appropriate government, but the employer has to make this contribution, and then the amount will be paid to the workers. Next. Code of Industrial Relations, Social Security, punishable imprisonment up to 1 year with 1 fine. This has been compounded now up to 50% of maximum fine, 75% of maximum fine, penalties to be given to the employer in case of prosecution. Next.